Hey, wise grasshoppers. We got 2 more PowerPoints to go. 2 more PowerPoints of new content. I'm excited, you're excited. And Chromio is going to take us into it. All right, civil liberties. Hope you got your note-taking guide ready. So let's dive on in and let's look at the difference between civil liberties and civil rights. When we're talking about civil liberties, we're talking about protections against the government or protections from the government, okay? We get our civil liberties in the Bill of Rights. And I know you just want to say, well, then why don't we call them civil rights if they're from the Bill of Rights? I know. But just remember what Thomas Jefferson was talking about when he said the right to life, liberty, and property. Liberty is everything in those first 10 amendments. Speech, press, religion, assembly, petition, all in Amendment 1. Those are all your civil liberties, okay? And like I said, coming from the Bill of Rights, the challenge is that people cherish these rights until their own are usurped. So you think that you have absolute free speech, you should be able to say what you want, but the KKK, they should not be able to say what they want. So there is a pretty clear conflict, and we'll talk about that. So free speech is a really good example of one. You can say, I hate the KKK, but the KKK can also say that they hate you. It's totally fine. When we're talking about civil rights, these are protections from people, okay, who are in the government or just individuals. Sometimes you might think of civil rights being reserved for positive acts of the government. Just think of the Civil Rights Movement and when LBJ signed the Civil Rights Act, the Voting Rights Act. Those positive acts seek to make constitutional guarantees a reality for all people. Civil rights is attempting to guarantee equal citizenship, voting for all. So, you know, it's good stuff for sure. Okay. So if you want to write that it's a good example is the Civil Rights Act of 1964, that wouldn't hurt. Okay. So in looking at the scope of the Bill of Rights, I need you to understand that when those 10 were ratified by the states by 1791, keep in mind that every other state, you know, all 13 of them, had a constitution and they had a Bill of Rights too, okay? You can go back and you can look up Georgia's original constitution, and it probably said something about free speech for Georgians or the right to bear arms for Georgians. But in terms of the federal government, excuse me, these first 10 amendments were intended to restrict the new federal government, not the existing state governments. So look on your note-taking guide and make sure that you're writing in that this originally applied only to the federal government and not state governments. Just think of the First Amendment. It begins with the words, Congress shall make no law, right? Congress being the legislative branch of the federal government. And these just show you all your various civil liberties. We'll be diving into these in more detail. So on your note-taking guide, I have a spot that says case. And the case that I'd like you to write in there is Barron versus Baltimore. If you want to write 1833 just for historical context purposes, go for it. This is not one of your 15 cases that you need to know for the exam, just FYI. And if you're thinking, but Eder, we don't need to know it for the exam because we're not doing the SCOTUS question. Yeah, but guys, this unit could appear in FRQ 1, just like Unit 1 could. So I'm sure they're going to come up with a way to get creative, okay? Also, you could cite any of the 15 court cases in your argumentative essay for, you know, additional support for your argument, whatever your argument may be. Alrighty, so basically what happened in Barron versus Baltimore is John Marshall, the Chief Justice at the time, said that the Bill of Rights really don't have any intention to apply to a state government, and the court can't apply them. In other words, the Bill of Rights really does not restrict state governments, it just restricts the federal government. Then everything changed with the addition of the 14th Amendment. There it is in all of its glory. Well, part of it. This is the really important part. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. That's Clause 1, the Citizenship Clause. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, also known as a Privileges and Immunity Clause. Nor shall any state deprive any person of life, liberty, or property without due process of law, also known as a Due Process Clause, nor deny any person within its jurisdiction the equal protection of the laws, also known as the Equal Protection Clause. So everybody, it is the 14th Amendment that is going to come into play and specifically get states to recognize the rights of all persons. So whereas before in Barron versus Baltimore, you have the Supreme Court saying, no, the Bill of Rights just applies to the federal government. So if somebody was suing Georgia over a free speech issue, the Supreme Court, because of precedent set in Barron versus Baltimore, would say, sorry, that's not the First Amendment. It only applies to the federal government, not states. Same thing with a gun issue, you know, with the right to bear arms in the Second Amendment. You guys aren't going to believe how recently this Supreme Court said, oh yeah, that applies to states too, not just the federal government. It's going to blow your mind. Anyway, so it's the 14th Amendment that applies specifically to states respecting the rights of all persons. And it does so with 3 clauses, the ones I just read to you. They are the Citizenship Clause. In other words, if you're born here, you're a citizen and you're entitled to all rights of citizens. The Due Process Clause. Do you guys recall where else we see the Due Process Clause in the Bill of Rights? I'm hoping some of you out there are answering 5th in your bedroom or the living room or the sunroom, wherever you're listening to this. Yeah, the 5th Amendment gives us due process initially, and it says that the federal government cannot deny you the right to life, liberty, or property. The 14th Amendment, through its Due Process Clause, says that the states cannot deny you of life, liberty, or property without due process of law. And then you've got the big one, arguably the biggest one, and that's the Equal Protection Clause. Guys, this is where equal opportunity comes from. This is where any case that involves discrimination, SCOTUS will cite in their opinion whether or not they believe the Equal Protection Clause to apply. All right, so I know I've told you that the 14th Amendment suggests that states cannot deny people life, liberty, or property. But what about all that other stuff? What about, you know, the right to bear arms? What about free speech? What about free religion? My darling dears, this is known as the incorporation case. Feel free to write that out to the side. I know your note-taking guide says what case incorporated the Bill of Rights, but I mean, it's this one. This one Supreme Court case starts the domino effect of ensuring that the Bill of Rights begin to apply to state governments as well as the federal government. So everybody, I'd like to introduce you to Mr. Gitlow, a socialist. In New York, he distributed something called the Left-Wing Manifesto, trying to establish socialism through strikes and class action. He was convicted under New York's criminal anarchy law, and he said, but there was nothing that resulted from what I was saying. Why can't I just say it? What's the issue there? And the Supreme Court said, yeah, you're right. Freedoms of speech and press, those are fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairments of states. So if we're denying you life, liberty, or property, the states can't do that. And in this particular case, that liberty is free speech. So everybody, this incorporated the First Amendment to the states, and it did so using the 14th Amendment Due Process Clause. So a wise grasshopper would know that the 14th Amendment is the incorporation amendment, and the 14th Amendment incorporates the Bill of Rights, in other words, makes it extend to state governments through the Due Process Clause. So this is essentially everything I was just telling you, that Gitlow began the selective incorporation process. Take a wild guess why we're going to call it selective incorporation. It means it doesn't just do it in one fell swoop. It does not occur all at one time. It's a gradual process, and it starts with free speech of the First Amendment. But hopefully you're realizing that's not all that's in the First Amendment. There's also religion, press, assembly, petition, and what kind of speech. So as you can tell, or as you can guess, there's a lot more that we're going to learn together. Let's do it. Okay, Amendment 1, I thought it might be a good idea for us to start first with religion. Okay, so Amendment 1 says that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise of. I hope you guys can tell that that says two very different things. Look at the break with the comma. Congress shall make no law respecting an establishment of religion. My darling dears, allow me to introduce you to the Establishment Clause. And the second part, or prohibiting the free exercise thereof, let me introduce you to the Free Exercise Clause. Let's do establishment first. Okay, I think this is going to be pretty straightforward for you. Obviously, our religious liberties originated in colonial opposition to government-sponsored churches. I mean, goodness gracious, just think back to Henry VIII, his daughter Bloody Mary. I mean, scary stuff, right? So the First Amendment contains two fundamental guarantees of religious freedom, which is why so many people came to this country. With the Establishment Clause first, where Congress prohibits an establishment of religion, and then followed by the Free Exercise Clause, which prohibits government from interfering with the practice. Okay, so let's do establishment first. Again, it says Congress shall make no law respecting an establishment of religion. So this very clearly says that we cannot have a national church of the United States of America. Are there countries that have churches? Oh yes, there are. The Church of England, you know, the Anglican Church, that's one. Many others. But basically what this is going for is that wall of separation that TJ suggested needed to exist between church and state. Not only would that prohibit favoritism, but it would also not give any support for religion at all from the government. Here's how TJ breaks it down. It does me no injury for my neighbor to say there are 20 gods or no God. It neither picks my pocket nor breaks my leg. Next time you find yourself getting into an argument over religion, feel free to quote TJ. And you know what? I might take my own advice and do that. All right, so let's look at some cases that involve the Establishment Clause. Oh, there's your wall of separation. Nice addition there, Eder. Okay, everybody, it's one of your 15 required court cases. Draw a little star by it. And I'm going to fly through these because your peers are currently working on case study projects devoted to each of these, okay? So Engel versus Vitale, this is one of the cases that you should know about, okay? And it's one involving school prayer and ensuring that the Establishment Clause does not just pertain to the federal government, but also pertains to New York and what their public schools were trying to do. So this said that prayer in school violated the Establishment Clause. And again, I'm zooming through this because your classmates are going to cover this in depth. This one your classmates will not cover, and this is Lemon versus Kurtzman. This is not one of your required cases. This is just, you know, extra for you. The Lemon case had to do with parochial schools, and parochial schools are like Catholic private schools or other religious schools, but usually Catholic. And what was going on is they were taking federal money to supplement their teachers' wages. And, you know, some people got upset about that because that was federal, or not federal money, or state money. And so the Supreme Court stepped in and said, okay, look, if you're a private school, you're obviously, separate. You're not supposed to get money from the state or federal governments. But if you do, you've got to meet these 3 tests. And this is known as the Lemon Test. 1, the money has to go towards a secular purpose, so nothing religious. 2, the money cannot advance or inhibit religion. So you can't use it to buy Bibles, and you can't use it to buy a book that says the Bible is false. And number 3, the money cannot be excessively entangled with religion, okay? You have to show exactly where every penny for every dollar is going. And when you give to a private school, that can be tough to do, okay? That can be really tough to do. So for example, teachers' salaries for parochial schools, they could be partly funded by federal government money if they're teaching subjects also found in public school like U.S. history. It just can't be religion. Okay, so that is the Lemon Test. There you go. By the way, this could all change right now. And it's so interesting because the Supreme Court, they heard this case, Espinoza versus Montana, before, COVID-19. And so they heard oral arguments. They're having their, conference meetings, most likely by phone, some by Zoom. And they'll probably issue an opinion on this soon. And this could totally change what I just told you, that precedent from 1971. So, wow. There you go. Cool article. Check it out if you want. Okay, now let's talk about the free exercise clause. So in this clause, it says that basically each person has the right to believe what they want. The problem is, though, believing something and then acting through your beliefs, that's a little different, okay? Also, what you believe, sometimes that can conflict with society's values and society's laws. So where we get into practicing beliefs, that's where it can be a little sticky. And let's jump into, actually skip where it says cases involve number 1 and go to number 2, okay? And write in Employment Division versus Smith, and that's 1990. All right, so these 2 Native American men worked for a private drug rehabilitation organization, okay? That's who they worked for. And they were American Indians, lived on a reservation, and they used peyote in their religion. So peyote comes from cactus, and you ingest the buttons, and it acts as a hallucinogen, okay? And their private drug rehab that they worked for drug tested them. They tested positive, so they were fired. And then since they were fired for drug testing, Oregon, the state that they lived in, said, no, you don't qualify for unemployment benefits. And these 2 Native American men said, this is bogus. You can't do this. So here's what SCOTUS said. The government can act when religious practices violate criminal laws, offend public morals, or threaten community safety. SCOTUS has never held that an individual's religious beliefs excuse them from compliance with an otherwise valid law. And it's interesting, though, because, Native Americans are sovereign. So can Native Americans use drugs in religious practices? I mean, yeah, technically. The SCOTUS did not say, no, you can't do that. And mostly because they're Native Americans. But can employers fire them for failing a drug test? And can the state deny them unemployment benefits? Yeah. Yes. Scalia said that if we allowed exceptions to every state law or regulation affecting religion, we could open the prospect of constitutionally required exemptions from civic obligations of almost every conceivable kind, like Compulsory military service if you get drafted and you say, oh, I can't serve because of my religion. Paying taxes. Oh, my religion doesn't believe in paying taxes. Vaccination requirements. That's very timely, isn't it? All right, so free exercise. It doesn't include everything you'd like to do. It is limited. Here's another way that it's limited. Reynolds versus the U.S. And there isn't a spot for this one. If you want to write it out to the side, that's fine. But this was in 1879, and this dealt with polygamy. Mr. Reynolds had more than one wife. He was charged with breaking Utah law. He said, it's my freedom of religion. SCOTUS got involved. So yet again, SCOTUS is making a distinction between religious beliefs and practices. Again, and keep in mind they said this before the previous case, because that was in 1990, 121 years later. In 1879, they said that the court cannot restrict what a person believes because that lies solely between a man and his God. But society has a right to legislate against religious activities that violate a law of the land. So they did rule against Reynolds and said that it violated a law of the land. But again, this happened before the coronavirus pandemic. Utah is voting to potentially decriminalize polygamy. So that, my dears, could go against this precedent too. I mean, dang. It's interesting. Changes in a second, y'all. Okay, now go back to number one. I should have covered this. Number one is Wisconsin versus Yoder. Wisconsin versus Yoder. And this is one of your required 15 cases, so I'm just going to fly through it. Yoder is spelled Y-O-D-E-R. And I'm going to let you get this from your classmates later. But it basically says that Amish parents can take their kids out of school after the 8th grade. Can. So in that case, freedom of religion overrode state education laws. Okay? I know that doesn't seem like I'm talking about it very much. But again, we'll do that more later. Okay. And for your third free exercise clause case, you've got the Church of Lukimi Babalu I versus the city of Haile. You guys heard this Sublime song? I don't practice Santeria. I ain't got no crystal ball. Anyway, it makes me think of this case because this case involved the Church of Santeria, which does involve religious animal sacrifice. So what they would do is in their worship, the animal's carotid arteries would be cut, and usually then the animal is eaten. And so, I don't know how to say the city in Florida. Is it Hialeah? I'm sorry. So right after they found out this church was coming, residents in the city put together several city ordinances addressing religious sacrifice. In other words, prohibiting possession of animals for sacrifice or slaughter. So the question here was, they felt as though these laws were burdening them and targeting them specifically. So SCOTUS had to look at the question, if these laws are passed, then they're not applied neutrally. Is that okay? And SCOTUS said, no, you can't just pass a law targeting one group specifically. We're going to really scrutinize those laws. We're really going to look at those laws. You've got to show that those laws or ordinances advance compelling state interests, and they have to use least intrusive means possible to protect public interest. And getting rid of a core part of Santeria and animal sacrifice, that's not, I mean, that is intrusive, right? So can animals be sacrificed during religious ceremonies? Yes. Can you write a law that specifically targets a church to stop them from doing this? No. Can they do it in public? Probably not. Okay, great crash course. Watch it. I'll put together a playlist on the YouTube channel for you. Okay, now let's talk about the right of expression, which, as you can imagine, is going to include speech, press, assembly, and petition. Okay, so back to Amendment 1, starting again with that first sentence, Congress shall make no law. And now let's go to abridging the freedom of speech. So obviously the framers believe that free speech is a fundamental national or natural right, correct? And the First Amendment protects this. And of course, the 14th Amendment through what clause? I hope you said due process. Protects this from incursions of both the federal or state governments. First federal, 14th state. Go ahead and take in this political cartoon for a moment. I'm sure you guys have heard of the Westboro Baptist Church. I warn you, images on this next slide are graphic. But I show you this because what they're doing is constitutionally protected speech. I don't like it. I mean, I'll just tell you, I don't like this church. I'm not a fan of the Westboro Baptist Church. By the way, it's very small. Very, very small. This is what they do. They show up at military funerals because they believe that soldiers dying is God's wrath because our society has become too accepting of homosexuality and other sins. Anyway, but they have the right to do this. It's constitutionally protected freedom of expression. Don't worry, plenty of people show up to picket them too. Also, the house across the street from their church in Kansas painted a very large gay rights flag on their house. So there's that. Okay, so we cannot talk about freedom of speech and the press without talking about the clear and present danger test. Now, I'm going to zoom through this because, yet again, this is another one of your ding, 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 15 required court cases that you must know. So I will go very fast in telling you about Schenck versus the U.S. And yes, there's two C's in Schenck. It's a tough one. It's a tough one. Long story short, Mr. Schenck encouraged people to resist the draft. He was arrested for violating the Espionage Act, interfering with the U.S. war effort. And SCOTUS upheld that limiting freedoms during times of war and for national security is constitutional. In other words, your free speech, it ain't absolute. Schenck said, well, the Espionage Act is unconstitutional. I have free speech. And SCOTUS said, nah, not during times of war, you don't. Not if we're putting your free speech up against national security, you don't. Justice Oliver Wendell Holmes, in writing the majority opinion, said that the character of every act depends on the circumstances in which it is done. The most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. The question in every case is whether the words are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about substantive evils that Congress has the right to prevent. Okay, so you cannot shout fire in a theater. What else can't you do that would cause a panic? Say it out loud. I'm guessing a number of you said bomb in an airplane or gun in school. Yeah, you can't do those things. Even if, oh, it was just a joke, it's not real. Sorry, you're in big trouble. You cannot do that. That is not protected speech. So again, free speech, not absolute. Another example of this is Brandenburg versus Ohio. Oh, I talked about the Westboro Baptist Church. Now we get to talk about the KKK. Mr. Brandenburg was like the grand dragon of the KKK in Ohio. There he is, supposedly, figure on the left there. Although I think he's supposed to have a different color outfit. Anyway, what he did is he invited television crews to come to one of his rallies. And what he said at the rally is they burned a cross there. If our president, our Congress, our Supreme Court continues to suppress the white Caucasian race, it's possible that there might have to be some vengeance taken. Okay, so he violated an Ohio law for advocating for crime, sabotage, violence, or unlawful methods of terrorism as a means of accomplishing industrial or political reform. He was convicted by Ohio. The Court of Appeals held that conviction up, but the Supreme Court overturned it. That's right. The Supreme Court overturned the conviction of the Grand Dragon of the KKK, or of that area anyway. Basically, they said, you can say what you want. That's fine. And the KKK can still say what they want. They can still have their parades. They tried to adopt a mile on a highway a couple of years ago in Georgia. But if they can say whatever they want until it incites lawless action. Okay? So if he's saying, that quote that I just said, they might need to be recognizing that them ignoring us could bring about some vengeance on our part. That's not inciting it. If he said, let's go and kill them all now, that's inciting it. I hope you guys see the difference. Okay? So far, we've said your speech cannot create a clear and present danger, and it cannot incite a rebellion. You with me? Okay. Now, let's talk about when you're not exactly saying it. Okay, symbolic speech. I've got two examples for you here, and I'm going to fly through this first one because it's one of your 15 required court cases, and I've got some of your peers working on that now. When I say symbolic speech, I'm talking about nonverbal communication, like throwing up a peace sign to somebody, carrying a sign like those Westboro Baptist church people, wearing armbands, as in the case of Tinker versus Des Moines. Feel free just to write Tinker versus Des Moines and don't write the whole thing, or burning a flag. So again, you're gonna hear about this, but they were allowed to wear these armbands to school. School suspended them because there was a rule saying that they couldn't wear anything, for or against the Vietnam War, and that would create a disturbance. And these two students, brother and sister BT Dub, wore these to school and got expelled. And so they took their school to court. Isn't that always fun? And they won. They won. They said that students and teachers do not shed their constitutional right to freedom of speech or expression at the school gate. The other symbolic speech case is Texas versus Johnson. Of course, they had to do this in Texas. So the year is 1989. This is not one of your required court cases, so I'm going to dive in a bit here. And Mr. Johnson is protesting homelessness in Texas and the lack of the Texas government to intervene and help these individuals. And on the steps of the Texas Capitol, he burns an American flag. And I'm sure some of you out there are going, what? I know. He did. Burned the American flag. He was convicted under Texas law, you can imagine, because Texas had a law saying you can't do that. And he took his case all the way to the Supreme Court. And the Supreme Court said, no, he can do that. It's symbolic speech. He can do that. Now, if he burned it and shouted, let's go burn the courthouse, that's when it's not okay. Because what is he doing then? He's inciting a riot then. Now, do I recommend that you burn the flag? No. No, of course not. Here's why. One, it's not smart to play with fire. And two, it's not smart to play with fire. I mean it in a literal and a metaphorical sense, okay? The Supreme Court has ruled that the First Amendment does not protect symbolic speech intended to incite illegal actions, like what I was just saying. So states can make it a crime to burn a cross if you're trying to threaten, terror to people of a specific race. Ooh, more limits on free speech. You think you have all this free speech, and you do. You have 99% of the free speech you think you have. It's just when it interferes with someone else. And here are two cases, libel and slander. Okay? Neither protected by the First Amendment. Okay. So the case involved here is New York Times versus Sullivan. This is not one of your required cases, so I'm just going to go ahead and tell you about it a little bit. So what happened here is the New York Times ran a full-page story talking, or paid for by supporters of MLK, that criticized the police in Montgomery, Alabama. Talked about how they mistreated civil rights protesters, talked about how many times King had been arrested, and there were some inaccuracies. So the Montgomery Police Commissioner, Mr. Sullivan, sued the Times in the local county court for defamation. In other words, defaming his character, his person. And he won and was awarded $500,000 in damages. And the Times appealed to the Alabama Supreme Court, which you're going to guess who won there, Mr. Sullivan. But then it went to the U.S. Supreme Court. And they ruled 9-0 that Alabama violated the First Amendment. Because in order for there to be libel, which is a written lie, or slander, which is spoken lies, just think slander, S, spoken, S, there has to be something called actual malice. In other words, you have to know that what you're writing is false, and you have to print it anyway, and maybe, you know, the whole time you're doing it, laugh a evil laugh or something, okay? This is tough to prove, though. So when it's a statement about a public figure, it's libelous only when it's false and purposefully malicious. You have actual malice intended. This is tough because the burden of proof is on the plaintiff. They have to prove that you knew it was false and you printed it anyway, hoping that it would hurt their character. And I mean, you know, you can say, oh, well, a reporter told me this, or a source told me this. So proving actual malice is really tough. That's why celebrities, when those terrible tabloids run articles about them, they very rarely are going to get the opportunity to sue and win, because the people working for those, you know, trashy tabloids can always say, well, I had a source. Now, obviously, if somebody says that Jennifer Aniston gave birth to a bat baby, then she might be able to win for that one, if she cares to do it, you know? Obscenity. This is always a fun one to talk about in class. Obscenity is tough because what you consider to be obscene might be different from what your neighbor considers to be obscene. What you consider to be obscene in 2020 might have been different from 2001 or 1980 or 1950. I mean, people thought Elvis was obscene. You know what I'm saying? A little different these days. Some works of art that some people call obscene might be works of art to others. Yet another wonderful Parks and Recreation reference we can make with Leslie as the female centaur, the nude female centaur. There is no nationwide consensus that suggests that offensive material should be banned. I want you to think about it. You have to be of a certain age to see an R-rated movie if it has nudity, right? HBO, if you want to watch a show on HBO that contains gratuitous sex and violence, what do you have to do? You have to pay for it. Just like if you want to get an issue of Playboy magazine, or Playgirl, you have to be a certain age. You've got to go to a place where they sell it. I mean, there's all sorts of regulations around this. So we see this in the case of Roth versus the U.S., 1957. Just think about this, 1957. And basically what happened, this guy wanted to open up a bookstore, so he sent out advertisements with naked people on it. And I want you to just, picture you're going out to the mailbox. Maybe it's your little sibling who's in elementary school and they're skipping and they're, they've got an ice cream cone just to, add insult to injury here. And they go, oh, a letter for mommy. Oh, here's a bill. That's not fun. And oh, what is this? Oh my gosh, what am I seeing? It's a naked picture. So that's the problem. If you want to see that, you have the right to see it, but you have to pay to see it. It just cannot be sent to your mailbox. And Mr. Ross said, well, I have free speech and press. Why can't I just do that? And the United States said, no, obscenity is not within the area of constitutionally protected speech or press. And just wait, it gets better. It was Justice Potter Stewart who said, I'll know it when I see it. Okay, so then we have the case Miller versus California, a little bit later, 1973. And it's a very similar case, nude advertisements. Here, the Supreme Court tried to clarify what can be classified as obscene. And what they said that's different in Miller compared to Roth is they said that the decision should be made to reflect the standards of local communities, not national. So there's nudist colonies. You can be nude in a nudist colony, but you cannot be nude in Marietta Square. Okay, you can't. Please don't try. You will get in trouble. Also in San Francisco, they actually passed an ordinance on it now, but when Dr. Webb and Miss Colacerdo and I went to San Francisco in the Castro district, they were just naked men hanging out, sitting in on a bench or standing in the middle of the day. And, based on community standards, that was not considered obscene. And I was scarred by that experience. It's burned into my brain. But again, it's a local standard. It's not a national standard. So it might be obscene there, but it might be obscene here, but it's not obscene in San Fran. Another crash course for you. Okay. And I forgot one. I'm sorry. Fighting words. Fighting words. You can't say to a person, I'm going to beat you up to the point where you are unrecognizable. That's fighting words. You're obviously intending to cause them harm, or you're intending to incite an immediate breach of peace. So you cannot say to a person, I'm going to kill you, and say, oh, I'm just joking. No. So don't do that, okay? Don't do that. All right, moving on to free press, okay? So Congress shall make no law abridging the press. We have this fabulous concept of prior restraint. Now, we've gone over this a little bit, holding someone back before they're doing something. This is suggesting that a government's actions stop material from being published. You might call it censorship. You can't do that. Now, you can be punished after publication. Don't forget about libel and slander, but you can't stop them from publishing it. Now, you can slap an explicit label on something, but those are okay. And we have free press versus fair trial. Interestingly enough, there are no federal shield laws for reporters. Some states have passed them to where they have to expose who gave them information. And this just shows you the current state of reporters' privileges nationwide. Some states do have shield laws, others don't. So the burden is on the government to say why withholding information is not okay. Okay. Okay, so it is a form of censorship, like I said, and SCOTUS has repeatedly ruled that using prior restraint is a violation of the First Amendment protection of freedom of press. And an important case or important cases for this, you will not see either of these. Well, actually, you will see New York Times Company versus the U.S. It's one of your required cases. So I'll let the group talk about that, who's making the presentation. But Neer versus Minnesota, What went down here is Mr. Neer in Minnesota accused local officials of being implicated with gangsters, and that violated the public nuisance law. And Minnesota had a gag law saying that you could not have anything obscene, lewd, malicious, or scandalous printed in newspapers. Well, then let me ask you guys, what would ever be printed in a newspaper? Okay. So again, that's the Supreme Court upholding prior restraint and ensuring that the federal government does not restrain a newspaper before they publish something. And New York Times Company versus the U.S., do you guys recall that's the case around the Vietnam War? Okay. Pentagon Papers. Okay. Let's look at assembly and petition. So Congress shall make no law respecting the right of the people peacefully to assemble and to petition the government for a redress of grievances. So let's talk freedom of assembly. This is the constitutional basis for forming our interest groups, guys, our factions, our political parties. If you want to picket, if you want to protest, all this stuff. Now, there's two facets of freedom of assembly, and that's the actual right to assemble, to actually come together. And then there's also the right to associate, to be a member of a group, okay? The government can place a reasonable restriction on time, place, and manner. For example, in 1941, SCOTUS ruled that you do need a permit for a parade. The KKK can have a parade, but they need a permit. Just like in Selma, Alabama, when the civil rights movement came there to walk across the bridge, they needed a permit, and of course were denied a permit by Selma, which is how the police said that they were lawful in stopping that protest. But any restriction cannot be applied because of content. It has to be applied to all fairly. And this is kind of that balance between freedom and order. And it can be tested when protests verge on harassment, like the Westboro Baptist Church. So the Westboro Baptist Church has to file for a permit to show up and picket, just like my club, the I Hate the Westboro Baptist Church, has to file for a permit to picket. And then you have the right to associate. We see this in the case out of 1958, the NAACP versus Alabama. Basically what happened, Alabama was trying to frighten members of the NAACP, ordering them to turn over their membership list. And SCOTUS ruled they don't have to do that. The right to assembly includes the right to associate. So if you want to be a member of a hate group, which I hope you do not, you can. You have the right to associate. But if you want to join my group, the I Hate the Westboro Baptist Church group, you can. Or maybe just I don't like them. Let's do that. That's better. Okay. I think that's Amendment 1. Up. We got some pictures. Here you go. The right to peacefully assemble. Peaceful assembly. Okay. Amendment 2. A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Of course, this is where everybody believes this is where your right to own guns comes from. And you're right, but you may not be, you're going to be surprised as to when the Supreme Court agreed with you. And then we also have this issue of, is this a collective right, like for a militia, or is it an individual right for an individual person? So DC versus Heller is not one of your cases, but McDonald versus Chicago is. And I know that the group who does McDonald versus Chicago will answer this question and go into depth here. So just on your note-taking guide for right now, make sure that you have written that McDonald versus Chicago incorporated the Second Amendment, meaning it made the Second Amendment apply not just to the federal government, to state governments. So the state cannot deny you the right to own a weapon, and that was incorporated in 2010 A little different from Getlow's freedom of speech in 1925, huh? So what this said is that they cannot ban owning a gun, but you can put limits on ownership requirement, or ownership requirements, excuse me. Okay, and I'll let the group talk more about that. All right, let's now talk about the rights of the accused. So in the original Constitution, there are a few individual rights listed, okay? And we've talked about this. This is what the Federalists cited, saying, we don't need a Bill of Rights. Look at these. And the first is habeas corpus. And habeas corpus is what prevents those unjust arrests and imprisonments. This says that you cannot be held in jail without being charged with a crime. Remember, it translates to present the body. Next, you have bills of attainder. And this is kind of maybe like the next level following habeas corpus. You can't punish someone without a trial. So it's true, you can't be held in jail without being charged with a crime, but you cannot be punished to life in prison without a trial. That's bills of attainder. And then you also have ex post facto laws. And these are basically laws that apply to an act committed before the law was enacted. So I give this example all the time, but if all of a sudden Colorado decides, we're going to make marijuana illegal again, they cannot go after everybody who went in the dispensaries when it was legal and arrest them. That's not okay. That's silly. So they can't do that. So all of those are rights of the accused that are actually in the Constitution. Now we're going to look at Amendments 4, 5, 6, and 8 that give the accused more rights. Okay, Amendment 4. You definitely need to make sure that you know that this is the amendment that gives us no search and seizure without a warrant, okay? And what I would know from Amendment 4 is what's called the exclusionary rule, the exclusionary rule. And this basically says that if there's evidence obtained through illegal searches or seizures, that evidence cannot be used in a trial. It's excluded. You can't do it. And this is established by the case Weeks versus the U.S. That's WEEKS versus the U.S. Now this gets tricky, so pay attention. What happened here is Mr. Weeks was being looked into by some local police, and they were trying to convict him of transporting lottery tickets through the mail. So they went into his house and they found the contraband and they brought it to court. And the Supreme Court said, you can't do that. You know why? They didn't have a warrant. There you go. And the warrant has to be specific. You have to say what they're looking for. You can't just say, I'm looking for illegal activity. No, no, nay, nay. You have to say, I'm looking for drugs, I'm looking for a weapon, etc. But that's not the case that incorporated it. The case that incorporated it is MAP v. Ohio. MAP, M-A-P-P, v. Ohio. Now, the Week case didn't incorporate the Fourth Amendment. In other words, did not make it apply to protections from the state governments as well, because lottery tickets are federal. There it is. But Miss Mapp, what happened here is police went into her home looking for something, but then they found obscene material, and they brought that into the, court for evidence. And that wasn't included on the search warrant. She said, I shouldn't be in trouble for that. And SCOTUS said, you know what? You're right. The Fourth Amendment, it doesn't just protect you from the federal government, it also protects you from states. And states need to have a search warrant to search your property as well. Okay. Now, the Fifth Amendment has a ton of stuff, guys. Oh my gosh. You don't need to write this down. Indictment by grand jury in a federal criminal court for a capital charge. If you're, up for the death penalty, a big jury decides that there's enough evidence to even hear your case. No double jeopardy. You can't be tried for the same crime twice. It's not just a very good Ashley Judd, Tommy Lee Jones movie. It's a real thing. But it also forbids forced self-incrimination. That's on your note-taking guide. That's why you'll hear people say that they plead the fifth or that they want to exercise their right to remain silent. Okay? Freedom from self-incrimination. You can ask me if I broke the law, but I don't have to tell you. I can plead the fifth. You're going to have to find some other way to prove that I'm guilty. So the burden of proof rests on the police and the prosecutors, not the defendant. Okay? It also guarantees due process of law. We've talked about that. The federal government cannot deny you life, liberty, or property. And probably the most famous case, of course, stemming from the Fifth Amendment. Oh yeah, eminent domain. The government can take private property and use it for public use. They just have to pay you, what is it called? Fair market value. Oh, good. There's the exclusionary rule. Good to know I already covered all that. Yay. Okay. So the famous case from the Fifth Amendment is Miranda versus Arizona. I'm sure you guys have heard about your Miranda rights. This sets the guidelines for police questioning suspects. That way you don't have to give people a get out of jail free card if you forget to tell them that they don't have to answer your questions. And that's what happened. Ernesto Miranda wasn't told that he could just shut up and not incriminate himself. And so he took it to court and he won, guys, he won. Don't worry, they got him on something else. But anyway, these created the Miranda rights, okay? And I'm sure you know them better than Channing Tatum. Go ahead, say them out loud. I know you'll be happy with yourself that you can. Yep, Jermaine Sound, yeah. Lawyer, that's right. You will be appointed one, very good. So do you guys understand all of that? You have the right to be quiet. You have the right to counsel. If you can't afford one, you'll be given one. And that comes into play with our next amendment. There you go. There's Bart Simpson for you. Here's more information on Miranda versus Arizona. Good crash course. Okay. The Sixth Amendment. All right. This is our guarantee of a speedy and public trial. It's also our guarantee of a trial by an impartial jury of our peers in the district where the crime is committed. All of those things are so important. It has to be an impartial jury. They can't know you. They can't have any preconceived notions or biases. It has to be of your peers. If you are a Spanish-speaking person of Mexican descent, there has to be a chance for a similar person to serve on your jury. And it does have to occur where the crime took place. Okay, you can petition for a change of venue if you feel like there's no shot of your client getting a fair trial where you are. Now, the Sixth Amendment says you have to be informed of the charges against you. You have the ability to obtain witnesses in your defense. You also have the right to confront your accuser. But here's the biggie. You have the right to a defense counsel at no cost to you. And we'll go over the incorporation case in just a moment here. The Eighth Amendment is not only no excessive bail or fines, it's also the big one, no cruel or unusual punishment. All right, so the Sixth Amendment says that the accused shall enjoy the right to have the assistance of counsel for his defense. So again, when the Sixth Amendment was ratified in 1791, this right did not apply to persons in state courts, only for federal courts and federal cases, because it wasn't yet incorporated, because the 14th Amendment had not been ratified. That due process clause was not in existence. This is the case that incorporated the Sixth Amendment's right to counsel. Gideon versus Wainwright. Your peers are going to put together a presentation on this, so that's all I'm going to tell you. Gideon versus Wainwright, 1963. Now, with the Eighth Amendment, it's really kind of interesting. Of course, they go after the death penalty with this, right? Most of the debate has been over that. Now, the incorporation case, Gregg versus Georgia, said that the death penalty, it is an extreme sanction, but it's suitable to the most extreme of crimes. So, in other words, cruel and unusual punishment does not mean the death penalty for the federal government or for state governments, okay? More recently, and I know you probably know this if you read Just Mercy, the court has ruled against the death penalty for 16 and 17-year-olds, or for those who are found to be mentally incompetent or challenged. But it really is in kind of a steep decline today because of more DNA testing and public concerns over wrongful sentences, like that horrible Netflix show. Oh, what was the name of that show? Let me go ask Sean. Stephen Avery, Making a Murderer, which, by the way, in season 2 totally looks like he did it. We stopped watching it. Anyway, but of course, there's still plenty of people who think the death penalty is the way to go and don't want to keep folks in prison alive for a super duper long time, you know, costing the taxpayer money. So, you know, you're either pro or you're against, or maybe somewhere in the middle. All right, fair trial procedures. Interestingly enough, I know I told you this last unit, but the vast majority of criminal cases today end in guilty pleas. You don't even go to a full trial. You have your pre-trial, and that in capital cases, so a murder case is where the grand jury has to indict you. They have to find enough information to bring charges. By the way, that's not required of the states, just in a federal capital case. Then you have your trial, where you can accept a plea bargain, or you can go to trial. According to the Sixth Amendment, you have your right to trial jury. And in a public trial, we're not allowed to bar press from the room in general. You know, freedom of the press, right? And you're supposed to have a public trial. You also do have the right of freedom from outside interference. You can request a delay or a change of venue if the publicity is too great. I'm sure Casey Anthony's mom did that, or the father of the 2-year-old who died in the car because of heat. But of course, does the freedom of the press conflict with the right to fair trial if they can publish all this stuff and show this stuff on the media before all the facts are there? Good question. Okay. Also, how long is too long? Because the government has to vigorously pursue the accused to give them a speedy trial. There can be limitations or other laws to mandate a quick time frame. You cannot just try a proxy. You have to try the individual. And the impartial jury, obviously, because of Jim Crow and other things, we do have a history of conflict, and including people of minority demographics. Hernandez versus Texas allowed for Mexican Americans to serve on juries. You can reject jurors. You can question jurors. I know if you guys have Miss Minnick, I'm sure she told you about that. States can decide if they need a unanimous decision to convict a person of, you know, more significant crimes. Then you have the sentencing phase, guilty or not guilty. The judge is usually who hands down the sentence. There's 3 strike laws, there's death penalties, and of course you can appeal it if you want. If you feel you were denied your due process or equal protection of the laws. Double jeopardy only applies for federal and federal cases, or state and state cases. Yeah, no go guy. Okay, and the 9th Amendment, these are our unenumerated rights. Probably one of the most well-known unenumerated rights, one that's not listed, is the right of privacy. And that usually comes into play with medical decisions, and we usually hear about it through abortion. Justice Brandeis defined privacy as the right to be left alone. The Bill of Rights does not specifically grant Americans the right to privacy. However, you can find parts of the Constitution that allude to it. For example, the First Amendment's guarantee of freedom of religion. You don't have to speak about your religion, explain it to people. Third Amendment, you don't have to keep forces or soldiers in your house. It's your private property. Same with the Fourth Amendment. It's your private property. Same with the Fifth Amendment, private property cannot be seized. So we see this in Griswold versus Connecticut, okay, 1965. And basically the Griswolds were a married couple, and they challenged the 1879 Connecticut law, saying that they could not use birth control. Yep. SCOTUS said, you know what? This law violates marital privacy. If they want to use birth control, whether it's condoms, whether it's the rhythm method, that is their prerogative. That's their privacy. So there you go. And that, of course, laid the foundation for one of your required court cases, Roe versus Wade. I'm not going to talk about it because it's one of the required 15, 1973. The ruling, abortion is constitutional in the first trimester. There have been some challenges to Roe. Planned Parenthood versus Casey. The Supreme Court took it a little bit further and said that abortion laws in nations cannot pose an undue burden to women, so you can't have a very long waiting period. If you don't want to tell your spouse, you don't have to in some cases. Minors do have to tell parents in some cases. The laws just cannot create an undue burden on a woman seeking the procedure. So obviously, y'all, our government is huge. We've got a lot of technologies. We as Americans can no longer avoid the attention of our government. And so we do need to limit our government's power. And thankfully, that is done so by the Bill of Rights, which now are incorporated to the states by the 14th Amendment. So in general, civil liberties do limit the scope of government. And just like that, guys, we are almost done. All right, so we've got one more PowerPoint, one more note-taking guide, and we are so close to being there, my dears. Thank you for sticking with me. I know this was a long one. We'll talk about it in our Zoom session on Friday. If you have any questions, hang on to it. And check out the YouTube channel for a playlist. And just know this is how I feel about you. May 11th. Just kidding. Be on that too. All right, everybody. You're the best. See you later.